wanna all night. Say it. I wanna all night. I wanna all night. Say it. I wanna all night.
Hello, stranger. It's been a minute since we last kicked it. And by the way, just got in town, and I won't let cumulus clouds all in the sky ruin my vibe. Usually I don't do this often, but since recruiting isn't an option, due to unusual rain and thunder, baby I wonder, would you just put your sweats on for me? Yeah. I got the plug, I made the call for me. I'm talking late night for you. Let me lay a great time on you. Don't hesitate, no, don't you? Just say you will. Come through and chill. Just say you will. Come through and chill.
I wanna all night. Say it. I wanna all night. I wanna all night. Say it. I wanna all night.
Hello, stranger. Babe's been waiting. Just as I recall that ass is still amazing. Playing baby, saying baby, love it shit, you know I'm crazy. So go ahead and put a drink up. I'm so glad we got to link up. Yeah, it's just taking that off of me. Yeah. I got the plug, I made the call for me. I'm talking late night for you. Let me lay a great time on you. Don't make me wait, no, don't you? Just say you will. Come through and chill. Just say you will. Come through and chill. Just say you will. Come through and chill. Just say you will. Come through and chill.
I wanna all night. Say it. I wanna all night. I wanna all night. Say it. I wanna all night.
Pick up the phone, show me it was real. Pick up the phone, show me it was real. Pick up the phone, show me it was real. Pick up the phone. Yeah.
Claps.
But I
I wanna all night. Say it. I wanna all night.
Hello, stranger. It's been a minute since we last kicked it. And by the way, just got in town, and I won't let cumulus clouds all in the sky ruin my vibe. Usually I don't do this often, but since recruiting isn't an option due to unusual rain and thunder, baby, I want.
What up, though, your moms? Hey, y'all. Did you miss me? Wait a minute, I'm being Cookie matching. Get up here, Cookie. What say you? Is that you matching with your mammy? Cookie said that's his fucking shirt. That's her shirt. Cookie, this is not your shirt. Are you calling me a liar? Child. We cannot. Okay. Cookie, like, back upstairs I go. Okay. She don't have time for the sea heads of it all. All right. Hey, y'all. Y'all see Cookie over there babysitting her little niece? Child, when I tell y'all, yesterday she was over here because her mammy and her pappy was going to the Lions preseason game for their little anniversary, child. They looked so cute, the little Lions gear on, child. Anytime the baby's Cookie, like, it's urgent. Get in here and check on this damn baby. Y'all, that's the cutest damn thing. Okay. Cookie said that's her damn baby. She don't care who think it's not. Okay. Child. So yes. Hey everybody up in this spot. Hey, Sweet Bird. How you been doing, Sweet Bird? I don't think I've seen you in a minute. Hey, Rose. Hey, Miss Ann Green. Hey, Miss Gloria. Hey, Deb, how you been doing? You been chatting? I ain't seen you in a minute either for the little court docs. Hey, Victoria. But I understand. I know it get damn exhausting, but y'all, we get action, okay? We are getting closer and closer to justice. Okay, closer and closer. We just got to pray that they see it our way and see what is, what is being broken. But I think they will. But we're going to digress and move on into this, okay? Because that's we going to see. Let me speak to, hey, Miss Victoria. Hey, Angela. Jean is not my lover. Ooh. Okay, period. Hey, Miss S.Y. Hey, Paulette. Hey, Appetite. Period. Okay. Hey, Miss Brenda. Hey, Nissa Girl. Hey, Lucky Charm. I like that name. Hey, Pilot Scat. Okay. Hey, Kim I. Hey, Miss T. No, with the Z. Okay, and that's on P. Who else up in this mode? Hey, Tay. Not you straight out of Compton. Hey, Angela B. Angie B. Hey, Miss Huff. Hey, lies and more lies. Hey, Mimi. How you been, child? Hey, Toy Squirrel. Hey, Regina. Hey, Me Mall 4. Hey, KBZ and the Heezy. Hey, sweet asses. Hey, Miss Deidre. And hey, Astute. Y'all, if y'all didn't see Astute video yesterday, please go on over there and watch it, okay? I'm going to put the link. Astute, put that link over here, okay? Put the link from your video from yesterday. And if PBE in here, PBE, put the link in this video for, I don't know if she want me to play it over here or because she need that views. Thank y'all. I dusted it off. I've been going to the hospital to see my friend in the hospital. And like she was supposed to get out Saturday, but now they're keeping her until tomorrow at least. So let's keep our prayers up for everybody that's sick and shut in going through our things. Hey, warm chocolate. Hey, Nene Yeah, a Stu video was really good yesterday. It was based really off, like, you know, showing again for the millionth time about the thing that really like started all of this shit. Really, like, hey KBR, hey Kim, hey love Key, like this shit, like, unfortunately, I think like this is like the biggest like beef that's ever been in this fucking section. Like, it's horrible. It is horrible. Okay. Hey Tiffany, they call you Stephanie. I call you Tiffany. Yes. So yeah, it's all stemming from that video. Well, the video I did before, but she showed a clip of what the video actually said, and all that stemmed to all the bullshit that's been going on, that has gotten deeper. But you know what? I'm used to defending myself. I always stand up for my fucking self. I don't give a fuck who behind me or who not. Okay? I'm gonna take up for me, for Tay. Okay. Okay. All right, let me get into it. Hold on, let me find it. She said I can play it. Hey, Miss Sandra, y'all come on in and make sure y'all hitting that like button, okay? And while I'm pulling that up, I'll tell y'all hyenas where I been, child. So I have this eye condition called iritis. It's like arthritis in your eye. And it flared up. I don't think I had a flare up maybe since, I don't know if it's been since I had this YouTube channel. If it was probably maybe like right in the beginning of when I started this YouTube, you know, well, started doing commentary on YouTube, because I had the channel for quite some time. But I don't think I ever had a flare up when I actually had the channel. If I did, I wasn't doing it enough to where you guys would know what it was, or, you know, having with my patch on or anything like that. Well, of course I wouldn't be doing videos because, what did I do this? Because, the muscle behind, the eye, my eyeball gets, swollen and inflamed, and it makes my eye really red and really sensitive to light. So it'd be a mess. Okay. It'd be a mess. Like, I can't just close my eye and make it better. Like, sometimes like the sun rays might shoot through this eye and get in it. And like, it just, when sun hit it, any light or anything hit it, it's just like boom, 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 boom. And it's just like bloodshot red. So usually I have to wear an eye patch, because just closing my eye, the lid doesn't protect it from the sun rays or any light or anything like that. So like, even like coming down from my bedroom, coming to the main floor in the morning time, like that sun, like, it's horrible. So I have to like literally put my hand over my eye to cover it, to keep any light from it. So I have, you know, like steroid drops I have to put in it and everything. And do you have it on a short PBE? Let me look on here. Yeah, here we go. So let me show this, and then we are going to get, hey, brown skin confessionals. Someone told me a seat. Wait a minute, what happened? What happened? Someone told me a C-head was live. Hey, Tay. Y'all see how Brownie them treat me? Where your drunk ass friend did them at? Okay, where she at? Where her antennas at? Is she out of rehab? Why you talking about me? Don't nobody in the chat speak to brown skin confessionals. Okay, we only know brown skin gal. Okay, if there's somebody in the chat named brown skin confessionals, I want brown skin girl to block them. Or any other mod in the chat. Uppity. Is this thing going? Uppity? I need you to block a raggedy bitch that's in my chat. Chat. Sorry, I'm just playing. Oh my God. I'm just playing. Brownie put a 1 in the chat if you not blocked. Child, now I gotta go through here, unblock damn Brownie. Child. Y'all up here don't play no damn games, okay? Child, now I gotta unblock Brownie. What has the world come to? What has the world come to? Now I have to unblock Brownie. Let me see here. Let me see here. Oh, she ain't blocked her. Okay. Oh, you not blocked. We see you. We see your raggedy ass. It was a close call because you know Uppy don't play no damn games, okay? And sometime when I'll tell her I'm playing fast enough, she be damn blocked. Oh, I can't. Yo, you can't block a mod. Let me unmod her. Use a lucky mother. Shut your mouth, hey. Okay, let me get into this thing. Because this song is so catchy.
This clown ass bitch then sat there and reported my Cash App, y'all. So I can't receive payments on it right now. And I haven't had a chance to dispute it or look into it because I've been busy.
Yeah, we see you. Not today. Snatch that bag. Yeah. If it's dirty, it's done. We out here cleaning the game up. Stopping bags all summer long, cause the bitch is wrong. Yeah, we stopping it. We don't let no scammers run the block, we on. Nope. Stopping bags all summer long, cause the bitch is wrong. Yeah, we stopping it. Messing with the hustle, girl, you won't last long. Yeah. Trying to run your little scheme, but we clocked you quick. Fake drip, fake talk, all counterfeit. People work too hard for the cash they get, so we taking back the bag, you ain't touching it. No pass for a snake, I don't play that role. Whole squad see the game, now the truth unfold. We protect what we earn, we protect our soul. Mess with the wrong ones, now you losing control. Stopping bags all summer long, cause the bitch is wrong. Yeah, we stopping it. We don't let no scammers run the block, we on. Nope. Stopping bags all summer long, cause the bitch is wrong. Yeah, we stopping it. Messing with the hustle, girl, you won't last long. Yeah. You was flashing online like the money was yours, but the truth hit hard when we kicked indoors. All that flexing and capping ain't impressing no more. Now you watching your bag roll out the store. We got eyes on the street and we talk real fast. If you running fake plays, you ain't think gon' last. Better check yourself, girl, learn from the past. Shutting off fake for me, cause the crown don't shine if it's made of glass. Cause she right, nah she wrong. Call what we do, crowd stop that song. Call she scamming all day long. We taking that bag, we don't play along. Stopping bags all summer long, cause the bitch is wrong. Yeah, we stopping it. We don't let no scammers run the block, we on. Nope. Stopping bags all summer long, cause the bitch is wrong. Yeah, we stopping it. Messing with the hustle, girl, you won't last long. Yeah.
This clown ass bitch then
shit. Hey, Rebel. Hey, Giraffe. Child. Okay. It sure sound better than the some other little songs that people been making up. But hey, that shit was good. Oh Lord, cooking. Okay, let me see. One of my neighbors are out in front of their house. I might have to go and close the door. Yeah, she's not gonna stop. Y'all listen to the song one more damn time, and we'll be right back.
I sat there and reported my Cash App, y'all, so I can't receive payments on it right now, and I haven't had a chance to dispute it or look into it because I've been busy.
Yeah, we see you. Not today. Snatch that bag. Yeah. If it's dirty, it's done. We out here cleaning the game up. Stopping bags all summer long, cause the vision wrong. Yeah, we stopping it. We don't let no scammers run the block, we on. Nope. Stopping bags all summer long, cause the vision wrong. Yeah, we stopping it. Messing with the hustle, girl, you won't last long. Yeah, trying to run your little scheme, but we clocked you quick. Fake drip, fake talk, all counterfeit. People work too hard for the cash they get, so we taking back the bag, you ain't touching it. No pass for a snake, I don't play that role. Whole squad see the game, now the truth unfold. We protect what we earn, we protect our soul. Mess with the wrong ones, now you losing control. Stopping bags all summer long, cause the bitch is wrong. Yeah, we stopping it. We don't let no scammers run the block, we on. Nope. Stopping bags all summer long, cause the bitch is wrong. Yeah, we stopping it. Messing with the hustle, girl, you won't last long. Yeah, you was flashing online like the
All right. Hey, Miss Chris. All right, so let's get into the we here for. Okay? Because we snatching bags all summer long because the bitch is wrong. All right, and that's on Piggy. So let me see. So y'all remember when I had received this, okay, from the OCDC of Missouri. If y'all don't know what them letters mean, okay, it also go to the remedial college as well. But also, it stands for the Office of Chief Disciplinary Counsel. Okay? Every state have one. I don't know if they call it the same thing, but this one in Missouri, this what it's called. Okay? So they sent me her response to her complaint. So you know that when she gets these complaints and they decide to move forward with an investigation, they send them to her. She has to retain counsel. Okay? She has to retain counsel for the complaint, and the lawyer has to reply back. Okay? I don't know if she really did this because I'm questioning the lawyer as well, but we digress. We're gonna move on. We got their ass together as well. Okay, so this is her response, but most of it is just she has 6 pages of her reply, and the rest out of 36 pages, I think And oh, these her attachments. Her attachments are this fake ass IC3 complaint that's supposed to be written from her daddy, but it's filed by her. And this is all the court docket. This is the whole court docket. Over 20 pages of just what's on the court docket. This. Yep. So we just gonna go over. Here is their enclosed is dear Ms. Garner. Enclosed is a copy of the response received by the Office of Chief Disciplinary Counsel from the attorney against whom you filed a complaint. If you desire to reply to the enclosed material, you should do so by August 20th, 2025. That's Wednesday. Please limit your reply to no more than 25 pages. Why the hell she get all these damn pages? I digress. Including attachments. Your reply should be sent to the above address and reference the file number above. After August 20, 2025, the complaint materials will be reviewed for any additional necessary investigation and for its consideration and decision with regards to the matters that you raised in your complaint. You will be notified in writing as soon as a decision has been made with regards to your complaint. Thank you for your cooperation. Sincerely, the Office of Chief Disciplinary Counsel. So here is her complaint. She has, looks like she obtained the Downey Law Group. We're gonna look up and see what they reviews and shit like that looking like, okay? To whom it may concern, please accept this letter as the response of Downey Law Group, LLC client Sarita McNeil to the complaint filed by Natavia Garner, and they give a file number. As discussed below, Ms. McNeil has not violated any ethical obligations in her dealings with Ms. Garner. Ms. Garner has never been a client of Ms. McNeil. Rather, Ms. Garner apparently harassed Ms. McNeil primarily through online conduct. Not apparently. I know you fucking lying. This resulted in Ms. McNeil suing Ms. Garner and other defendants in the United States District Court for the Eastern District of Missouri. And we know that she resides and works in the Western District. Okay. We'll get into that when we get to my rebuttal. Okay. Seeking injunctive relief and damages arising from injuries to herself and her business. Ms. Garner complaint raises only objections about Ms. McNeil how Ms. McNeil served Ms. Garner in that litigation. If Ms. Garner has legitimate complaints about service, she should raise those objections and obtain a ruling in federal court. Ms. Garner has not done so. Remember that. Okay, remember it said Ms. Garner had not done so. The OCDC is not the proper forum to decide issues relating to service of process in federal litigation. We therefore ask that you close this complaint against Ms. McNeil with no further action or investigation. A full explanation follows. Then they get a background of anonymous. As far as her education and stuff like that, which nobody need to know because she's not applying any of the motherfucking tools that she fucking did. You trying to get these damn schools and shit like this unaccredited. Facts that relate to the complaint. Ms. McNeil interacts with Ms. Garner on her social media channels discussing love and marriage Huntsville. In March 2020, Ms. McNeil began participating in social media discussions relating to the reality TV show Love and Marriage Huntsville, a series that is also available on various streaming services. Ms. McNeil's post gained considerable attention. What post? That's a lie right there. Resulting in Ms. McNeil being invited to participate on other social media channels, including Ms. Garner's YouTube channel, to discuss Love and Marriage Huntsville. Ms. McNeil's commentary on Ms. Garner's YouTube channel included providing information about legal tools that were available to the public for those experiencing family law issues. When did she get this commentary? Ms. McNeil also provided materials for how to spot behavior traits of people exhibiting mental illnesses. So it looks like, well, she told this attorney group that it looks like she was giving us tools to identify people with exhibiting mental illness, such as herself. So she taught us how to identify folks like her, how to set appropriate boundaries. So I guess when I sent that email to her about setting a boundary on how the fuck she should, conduct business and respect me on my channel, but she didn't like that. And how to have healthy and productive relationships, because she has so many, I'm assuming. We cannot. Thank you, Miss Deb. Ms. McNeil files a lawsuit against Ms. Garner and seeks waiver of service. Subsequently, certain social media influencers, including Ms. Garner, subsequently turned on Ms. McNeil, doxing her, publishing Ms. McNeil's real identity, contact information, and the like. Why do we turn on her? For what? And otherwise harassing Ms. McNeil. Ms. McNeil sought to defend herself, culminating in Ms. McNeil filing a federal lawsuit against Ms. Garner and other individuals. On or about December 29, 2023, Ms. McNeil filed a federal lawsuit in the United States District Court for the Eastern District of Missouri, seeking damages and an injunctive against 8 individuals, including Ms. Garner. 1, see docket report, and she gave a case number. And the 1, let's read that. Ms. McNeil also named Google, YouTube, and TikTok as defendants in Ms. McNeil's federal lawsuit to try to remove harmful content and protect Ms. McNeil's privacy and other interests. However, these social media defendants are not relevant for the purposes of this bar response. Then why the fuck did you mention said social media platforms if they're not relevant? Let's continue. She get a case number, an exhibit, and she says it's an exhibit A. So that's all those pages. Ms. McNeil also prepared a notice of lawsuit and requested to waive service of summons for all the defendants and sent each defendant, including Ms. Garner, asking them to waive formal service. Ms. McNeil then mailed requests for waiver of service and related documents to Ms. Garner and other defendants by certified mail, as provided in Federal Rule of Civil Procedure 4D. See docket report Exhibit A. Ms. Garner harasses Ms. McNeil on December 30th, 2023. Ms. Garner and another defendant, Felicia Moore, contacted Ms. McNeil's father, an attorney in Texas. Ms. McNeil understands that this communication was to demand that Ms. McNeil withdraw her lawsuit and to threaten Ms. McNeil if she did not. One of Ms. Garner's threats was to file against Ms. McNeil's bar license. Ms. McNeil's father subsequently reported this and other threats against Ms. McNeil when he filed an Internet Crime Complaint Center complaint with the Federal Bureau of Investigations against Ms. Garner and another defendant, Ms. Moore. CIC3 complaint, Exhibit B. Now, y'all keep in mind that in the court document, she said we made terroristic threats. But in here, she only referred to, mind you, her lawsuit was the day before this, December 29th. December 29th. Not she said the call to her father was on December 30th of 2023. But you already had put in your documents, your complaint the day before that you had been harassed already by me and made terroristic threats and things like that by me and the other defendants and all that stuff starting in July of 2023. So why are you only referencing this instance on December 30th, the day after you already have filed the complaint saying that these things were already happening to you? Why wouldn't you use some of those things as proof, since that's what you originally filed your complaint about? Ms. McNeil uses process service to serve Ms. Garner and other defendants. Ms. Garner declined to waive service of process as provided in FRCP Rule 4D. Therefore, on March 7th, the day after the GoFundMe goal was met, Ms. McNeil filed a notice of intent to use process service to serve the out-of-state defendants, including Ms. Garner. Ms. McNeil received the summons and engaged a process server through the website of the National Association of Professional Process Servers, but was unable to obtain service on Ms. Garner. On April 18, 2024, Ms. McNeil filed notice that the summons for Ms. Garner had been returned unexecuted. Ms. McNeil believes she did not have a correct address for Ms. Garner at that time. Subsequently, Ms. McNeil obtained additional information about Ms. Garner's employment that caused Ms. McNeil to believe she might be able to serve Ms. Garner through her place of employment in Texas. If you're suing me because of some shit you said happened online on social media, what do you need to know my place of employment for? Because at that time, my place of employment that you know of is YouTube. And YouTube was listed on the lawsuit. So what are you trying to find my employment for? You can't serve my employer. And you can't serve me at my place of employment. On December 26, 2025, which that haven't even happened yet, okay? Ms. McNeil requested an alias summons to serve the remaining individual defendants, including Ms. Garner, whom Ms. McNeil believed was evading service. That's not illegal. And if you only tried to serve me one time, why you not listening the other time? Why you not listening to private investigator right now? Why you putting them out of order? Why you didn't list the creepy guy there, the window peeker, the peeping Tom? Why you didn't list him? But you, from your little timeline today, right now, what you're putting right here, if you couldn't serve me one time, how did you conclude that I was evading service? Could it just been possible that one time I wasn't home? or the time of day that your process server was coming, I wasn't home. Which it could be a number of things, but she always jumped to the worst, because this is the type, this is what criminals do. They always jump to the worst possible thing. Hey, nice to see me. When seeking to serve Ms. Garner, Ms. McNeil had obtained information causing Ms. McNeil to believe that Ms. Garner was employed as a shift manager for Citgo Petroleum Corporation and could be served through Citgo. Why? Now, this looks like she's harassing me. And also, too, where she said she believed that she didn't have a correct address for me. Had you did your steps right, like y'all claim Maurice didn't, but had y'all did y'all steps like Maurice did and got the correct information through early discovery motions and subpoena Google and shit like that, they would have told you the correct information. And you wouldn't have to go through this and thinking and believing shit, because you would have it improved. Because since Google AdSense pay me, I make sure my information is correct with the batches. Okay. On February the 14th, 2025, Ms. McNeil filed a notice of intent to use process server A1 HuTech Civil Process to attempt service on Ms. Garner in Texas by serving Citgo. Ms. Garner's process server then served the summons and related. Ms. McNeil's process server then served the summons and related documents to Citgo's registered agent. Are you suing Citgo? Since you know all the fucking rules and shit like that and what's valid and proper venue and all that type of shit, were you suing Citgo? Because if you wasn't suing Citgo, why the fuck would you be sending a summons to their registered agent? And Citgo registered agent wouldn't accept motherfucking service because they're like, you not suing us. We not her. On February the 17th, 2025, Ms. McNeil filed a summons return for service on Ms. Garner. That, keep in mind, that's the deadline the judge gave her in the order she made January 21st, that she had to serve all the remaining defendants on the lawsuit, or she was going to dismiss them off. Hey, Miss Richard J. Ma'am, the way I be needing premium gas. Okay. Citgo, where you at? Ms. Garner files a motion to quash due to improper service. I thought you said I didn't do shit. Remember on this page right here? Was this the page? But y'all remember I had said I can't find it on here. Where she said that if I felt that that the service, my complaint, oh, maybe it was up here. We'll just move on. Y'all remember when she said that my only objection was that, you know, the improper service And if I had any questions about that, I should have filed that with the federal court, that I had not done so. But here in bold, Miss McNeil used Miss Garner, here's it down here. Miss Garner files a motion to quash due to improper service. This contradicting their own statements. In March 2025, Ms. Garner filed various motions claiming improper service. Ms. Garner's March 2025 motions mirror her allegations in this bar complaint. Ms. McNeil filed her opposition to Ms. Garner's motion, arguing that the service of process was properly executed under the federal rules of civil investigation, civil procedures. These motions are currently pending. The motion's not currently pending. The judge ruled on them and denied them as moot because she was accepting her amended complaint. So the new ones on her amended complaint, why the lawyer didn't mention that? About the amended complaint that got 20 motherfucking one people on it, single people and corporate defendants. Well, individual and corporate defendants, they never mentioned that in here. I submitted motions to quash, motion to dismiss, motions to strike, all of that. Ms. McNeil believes any challenges Ms. Garner might want to raise regarding service should be raised and addressed in federal court, not in the lawyer discipline proceedings. Response to Ms. Garner's specific allegations. Ms. Garner's bar concerns her displeasure at being sued and served in Ms. McNeil's lawsuit. Ms. McNeil will address each of Ms. Garner's specific complaints below using the same heading and characterizations that appear in Ms. Garner's complaint. However, Ms. McNeil believes the proper form to adjudicate Ms. Garner's issue is in federal court, not in the lawyer discipline matter. First of all, why don't you put it in the right district of the federal court to be addressed? Let's check that. A, frivolous and malicious legal filings. Ms. McNeil filed her lawsuit against Ms. Garner and other defendants as a result of the defendants' alleged notorious and unlawful conduct against Ms. McNeil. You see how he put alleged in here right here, but in the beginning paragraphs, he put that I apparently harassed her, not allegedly harassed her, stating an allegation as fucking fact with no motherfucking merits to back it up. I might file a complaint on his ass. Sorry, I ain't gonna file one on them yet. Ms. McNeil believes her allegations are true. We will hope she would believe them that they're true. Otherwise, they're definitely frivolous and malicious. And then she believed they were so motherfucking true. Why she ain't got us in criminal court? Where the criminal charges at? Based upon her knowledge and belief, and that she will be able to prove her allegations and recover against Ms. Garner in a lawsuit. How? When you losing at every motherfucking turn. From every damn defendant on this motherfucker. Ms. Garner seems upset with the allegations against her now. But Ms. Garner's personal feelings toward the allegation do not make the allegations false or defamatory. Now, this is why I question that this attorney, another attorney did this, because attorneys know better than to put stuff about feelings in there. What do you mean I seem upset? That has nothing to do with nothing. That has nothing to do with nothing. So they usually steer away from making accusations about somebody's feelings. You don't know how the fuck I feel. Thank you, Miss Bridget J. 914 for the $10 super chat. Doc dudes, period. Let me get you the money song, and we're going to continue on with the documentations.
Check. All I really want to see is us. I don't really need a D, I need us. All a bad bitch need is us.
Give me that money. Okay, and that's on P. In particular, the litigation privilege. Listen, pay attention. Remember this: litigation privilege. Okay, the litigation privilege protects Ms. McNeil from the defamation from claims brought against Ms. Garner. They do sometimes. If Ms. Garner has complaints about why Ms. McNeil filed the lawsuit or what Ms. McNeil alleges in the lawsuit, there are procedures for raising and adjudicating such issues in federal court. Did you see my countersuit in your exhibit? The fuck? Ms. Garner has taken steps to use these procedures, including filing a pro se motion for sanctions and a countersuit and a counter lawsuit. Not just no sanctions, batch. Against Ms. McNeil on May 15, 25. And then they put the little 2 and they say see Exhibit A. Now, let's read what they have in 2. Ms. Garner's co-defendant, Vera Calvin. Now, this right here was submitted July 17th. We know that PBE was an ex-defendant in July since May 2nd or 3rd. So why are you and your attorney putting in this lawsuit as one of your little cliff notes that Ms. Garner's co-defendant, Vera Calvin, filed a motion for sanctions against Ms. McNeil that raised some issues? What issues? Ms. Garner seems to want to raise some issues. Ms. Garner seems to want to raise against Ms. McNeil. I guess they saying that I wanted to raise the same issues that PBE raised, or that I'm raising issues for PBE. She off the case. The district court denied Ms. Calvin's motion for sanction in May of 2025. Yeah, because she was dismissed off the case. Oh, did I finish reading that? No, I did. Okay. Thus, again, the federal court and not the lawyer discipline process should resolve such matters, at least in the first instance. It's not the first instance. B, abusive process and harassing conduct. Ms. McNeil admits that she hired a private investigator to locate and process server to serve Ms. Garner. Ms. McNeil believes she hired a reputable investigator and process server, and that she needed to take such steps to locate and serve Ms. Garner because A, Ms. Garner had engaged in illegal and tortious conduct against Ms. McNeil. Again, allegations of crimes, of criminal activity with no proof. B, Ms. Garner sought to avoid service of Ms. McNeil's lawsuit. If Ms. Garner believes she was harmed in some fashion by improper conduct by Ms. McNeil's private investigator and process server, such issues should, again, be raised and adjudicated first in the federal court. There again, first, I did raise the issues there. Ms. McNeil further states that she took steps after she believed Ms. Garner was evading service. You can't make me accept service. But I digress. Thank you, Kim I, for the $10 cash app to make them mad. You broke batch ass. Wait a minute, Michelle. Thank you, Michelle Ward, for the $20 super chat. Not for the premium gas, child. No, I gotta get y'all the money song, okay? Because that premium gas ain't fucking cheap. Y'all know I only get gas from Sam's Club too. Don't tell Brownie when I go fill my tank up, okay? Because she like to report me to Sam's Club so they can be waiting for me. Period.
Tell them that it's a magic. Money, money, green, green, money's all I need. Money, money, green, green.
Thank y'all so much. Y'all are some fools, okay? Period. Okay, let me see what we got. Okay, C. Knowingly submitting false employment information. Ms. McNeil used several sources when seeking to locate and serve Ms. Garner because it appeared Ms. Garner was seeking to evade service. You can't tell me what I was fucking seeking. It is possible that one or more of these sources that Ms. McNeil reviewed contain inaccurate information. Backpedaling, pee-popping much? However, Ms. McNeil did not knowingly, they put in quotes, use any false employment information in her attempt to serve Ms. Garner. So you mean to tell me that a smart-ass bitch, such as your client, Mr. Downey, with all of these accolades, graduated with a bachelor's degree from Texas, University of Texas, bachelor's in accounting in 1997. Juris Doctorate degree from Missouri Columbia School of Law, 2007. Passed the bar exam in September 2007. Also got a accounting degree, a certified accountant in Arizona and Missouri. So you mean to tell me that they looked at their research, they submitted to the court, with 4 jobs on there, when all 4 of them had the same end date, and 3 of them had the same beginning date that was on January the 1st? Let's move on. Moreover, if Ms. Garner does legitimately believe Ms. McNeil has engaged in some misconduct in the litigation, Ms. Garner should raise such issues in federal court. The Missouri lawyer disciplinary system is not the proper location for a first adjudication of such matters. But y'all keep in mind, hey, Rally, keep in mind that they submitted the dockets from the court. So he clearly must have not read this shit. He clearly must not have read any other shit on the docket, because he would see all the motions and shit that I done filed about this shit. But I digress. We'll talk about it in the rebuttal. We almost done, y'all, with this one. extrajudicial public defamation. Ms. Garner is incorrect that the district court struck Ms. McNeil's submittal a supplemental response, docket number 185, because the district court rejected the merits of Ms. McNeil's arguments in that pleading. I didn't say that's why they struck it. I said since a document that has been stricken. I didn't say they struck it because of any merits. It was meritless, but it was the defamation in there that she submitted. That's what I said. The document she submitted that had been struck had defamatory allegations in there. Y'all remember the document she put in from True T? Lying and shit, defaming people's character. Rather, the district court reports it struck the supplemental response because supplemental response was filed in response to a reply that another defendant, Brim Moore, filed in support of that defendant's motion to dismiss, and was thus the fourth substantive filing or a surreply not permitted under Rule 401 unless the parties receive leave of court. So right here, he's just telling you that it wasn't struck because it had defamatory information in there. It was struck because abuse of process. She didn't follow the right process. She didn't follow the rules. She didn't follow the rules. Thank you, Miss Deidre, for the $20 cash app for document fees. Thank you. Let me get you the money sound.
Text money. All I really wanna see is us. I don't really need a D, I need us. All a bad bitch need is us.
Period. Okay. If Ms. Garner believes Ms. McNeil has done something improper in a pleading or investigative relation communication, Ms. Garner should seek relief from the federal court, not the Missouri lawyer discipline system. Further, the litigation privilege would protect Ms. McNeil's statements made in connection with her litigation. That's incorrect, and we're going to get into it, okay? E, failure to act in good faith and violation of duties of candor. To her knowledge, Ms. McNeil has not made or ratified any false statements that would validate or violate the ethical rules. It is possible. Here we go with the P popping again, backtracking. It is possible Ms. McNeil made an incorrect statement about Ms. Garner's place of employment, for example, but that does not mean Ms. McNeil knowingly made a false statement. I'm gonna have to ask, is this attorney cool? How is you cool? Let me see how tight I gotta do it with this here. How is you cool? And ain't. Rather, Ms. McNeil conducted research, and based upon that research, unverifiable research, sought information in good faith to obtain service on Ms. Garner. Further, as stated throughout this response, the district court is the appropriate venue to adjudicate, at least in the first instance. Rather, Ms. McNeil's claims are supported by the facts and law. Again, Ms. Garner may not be happy that she is defending herself in a lawsuit, but it does not mean Ms. McNeil has engaged in unethical conduct. And in conclusion, based upon the information above, we believe that Ms. McNeil has not violated any ethical obligations to Ms. Garner, the court, or otherwise. Rather, the issues Ms. Garner raises should be addressed in the pending federal litigation where Ms. McNeil has sued Ms. Garner. We therefore ask that you close this matter with no further action or investigation against Ms. Garner. The actions, they not against me. They against your client, mofo. Okay? So that's that. This is my little packet. This is what I sent to the chief disciplinary counsel yesterday. First class mail, no priority mail. Day one. One day it. Because I want to miss the 20th deadline, okay? Let's get into it. I emailed it to myself. So let me go to my email. Okay, let me go up so y'all can't see the address. I mean the case number. Oops. Go down. Okay, that should be good. Okay. Let me share my screen because it don't cost a thing. Hey, speak with your girl. Marcella, did you have a good birthday? I hope you did. Okay. Okay, let me move that up. Y'all so nosy and eager. To whom it may concern. This summary highlights the most serious concerns arising from attorney Saretha McNeil's conduct, as outlined in my attached rebuttal to her July 17, 2025 response. While Ms. McNeil attempts to dismiss these matters as routine litigation disputes, they involve false statements, reckless disregard for the truth, and procedural abuse, all of which fall within your jurisdiction to investigate as potential ethic violations under the Missouri Rule of Professional Conduct. Okay? Key issues for OCDC review. 1, false statements to the OCDC about service notices. McNeil told the OCDC she submitted a request for process service in December 26, 2025, but it was December 26, 2024, because she thought she may have an improper address. Also, please notice that an early discovery motion for subpoenas for YouTube channels would have been the proper process to obtain verifiable personal information, example, real identities and addresses. But McNeil skipped this process. Hence the reason why she has several of her 21 defendants' information and identities incorrect in her filings, per her Exhibit A of her response to this complaint. Court records, document 53, page 12 of her 36, show she did not notice A1 Hugh text until February 14, 2025, more than 6 weeks later than she tried to act like she required them December 26. She never filed a return or resolution for the December 26, 2024 notice, no indication whether service was executed or unexecuted. 2, improper service attempts before filing. A process server came to my home on February 12, 2025, video footage available, before Ms. McNeil filed her third notice of on February the 14th, 2025. Now, she never said anything about what that guy came to my house for. This is a direct procedural violation and undermines her credibility in statements to the OCDC. 3, knowingly maintaining false employment claims from Citco. I have repeatedly informed Ms. McNeil via court filings that I have not worked for Citco Petroleum Corporation in Texas and hasn't been affiliated with Citco for over 9 years and was a contract worker for an independent gas station owner. Ms. McNeil's own research from Checkmate and Rocket Research shows my employment with all listed jobs extracted from my LinkedIn but distorted ended on October 10, 2024. Despite this, she continues to file pleadings asserting I was employed by Citco on February 17th, 2025, and claims service occurred there nearly 4 months after her own documents indicate my employment ended, per her exhibits in her court filings. 4, pattern of reckless and dishonest conduct. Filing inconsistent service notices, using unverified employment data, and misrepresenting timelines to the OCDC reflect a disregard for truth and candor that extends beyond routine litigation disputes. Why this falls within OCDC jurisdiction. These acts are not isolated by litigation privilege or procedural forms rules because they involve false statements to a regulatory body, misrepresentation of procedural facts to the court, reckless reliance on unverified or disproven information. Requested action. I respectfully request that the OCDC investigate Ms. McNeil for violations of Rule 4-3.3, candor towards the tribunal, Rule 4-4.1, truthfulness in statements to others, Rule 4-4.4, respect for rights of third persons. Her conduct prejudices the administration of justice and damages the integrity of the legal profession. I am aware that in Ms. McNeil's prior disciplinary case, the Missouri Supreme Court case number, and here's the case number, her old discipline that she just had recently in 2020, mitigating circumstances were considered, resulting in a lesser sanction despite the seriousness of her misconduct. Those mitigating factors, whether personal, medical, or otherwise, were intended to encourage rehabilitation and deter further ethical violations. However, the conduct described in this complaint demonstrates that those prior accommodations have not resulted in changed behavior. Instead, Ms. McNeil has engaged in similar patterns of misrepresentation, abuse of process, and disregard for truthfulness, now in the context of the current federal litigations. Because prior mitigation failed to present reoccurrence, and because continued misconduct undermines public trust in the profession, I respectfully request that the OCDC do not apply any mitigating factors in determining the outcome of this investigation. The focus should be on protecting the public, deterrence of future misconduct, and preservation of the integrity of the legal system. And that's all under the mitigation not warranted, okay? 6, false and unsupported criminal allegations. Ms. McNeil continues to accuse me of serious crimes, including terroristic threats, doxing, harassment, and gang activity. In both her court pleadings and her reply to the OCDC, these allegations are unsupported and inconsistent. She never identifies what the alleged terroristic threats actually were. Filing a bar complaint or defending myself in litigation is not a crime. She claims these threats were made to her father on December 30th, 2023 through a phone call / text messages. Yet she had already filed her lawsuit the day before on December 29th, 2023, alleging harassment against herself and her family. This inconsistency undermines the credibility of her claims. She submits only a single IC3 complaint filed in April of 2024. Hey, welcome to Brett's Block. Months after alleged 12/30/2023 events. And notably, this complaint was filed by her, not her father. Despite accusing me of crimes, she provides no affidavits, no police reports from her or her father, and no direct evidence of any alleged threats. Using bar complaints, civil proceedings, pleadings, and OCDC responses to accuse another individual of criminal activity without evidence violates Rule 4-3.1, meritorious claims and contentions, Rule 4-3.3, candor towards the tribunals, and Rule 4-8.4, dishonesty. 7, misuse of fair litigation practices. Remember the litigation privilege they said that she was protected with? Ms. McNeil argues that her conduct should be excused as part of fair litigation practice. This is incorrect because accusing an opposing party of crimes, terroristic threats, gang activity, harassment is not a litigation strategy. It is a misuse of the court process when not supported by evidence. In her OCDC response, she again asserts criminal activity, but submits only one IC3 complaint filed by herself. And also I put in here, she never submitted this evidence into the civil court filings. She never submitted that IC3 complaint that she have in this packet. That she have in her packet, she never submitted this to the court. She never submitted this to the court. She never submitted none of this to the court. In her OCDC response, she again asserts criminal activity, but submits this. She never submitted it to the court filings, which does not substantiate her allegations. The authenticity of her documents is questionable, as she relies heavily on online research tools like Rocket Reach, Instant Checkmate, and vague, unsworn materials instead of verifiable evidence. Litigation privilege does not shield knowingly false criminal allegations. An attorney has a higher duty of candor and may not weaponize allegations of crimes to harass or intimidate. 8, improper service and refusal to provide affidavits. Ms. McNeil's reliance on Citgo Petroleum Corporation as an alleged service agent for me is improper. Citgo is not a defendant in her lawsuit and is not my registered agent. She persists in treating Citgo service as valid even after I repeatedly clarified I am not employed there. I requested sworn affidavits from the individual who supposedly accepted service on my behalf at Citgo in Texas, and from the service process server who claimed to have served them. Ms. McNeil opposed these requests each time. Her opposition to basic sworn affidavits, raises serious questions about whether the service ever occurred as claimed. Okay? I have serious concerns whether if they even said they served the shit, because if they said they served it and somebody took it, it would be nothing for them to submit an affidavit that they accepted the service, the person who accepted it, because they would have to sign off on it at the desk. Every corporation has a security desk. You just can't walk in there and just go to wherever. You at security. So you will have to go in the location. The process server will have to go in the location, let them know that they have a summons for Natavia Garner. They will look in their system. Can you spell that? Okay. I have nothing. No such employee exists here. But yet, instead of that, you saying that they took the service. Oh, okay, we'll take it. We'll accept it, and we don't even know this person, but we'll take it as we're their registered agent. No, that's not how any of this works. So your refusal to even provide the affidavit, sworn affidavits from the process server and the person that accepted the summons raised concerns to me. If the service even was, if they even told you that it was executed, that they did it. And I told y'all, I called that process serving company. So that's how I pretty much know for a fact that she's lying about this. But let's move on. This behavior shows deliberate misuse of process rules to manufacture a service record. By opposing affidavits and relying on improper service, she attempts to maintain falsehoods as facts while avoiding scrutiny. 9, pattern of dishonesty and evasion. Even in her OCDC response, Ms. McNeil concedes she may have made a mistake regarding my employment at Citco, yet she continues to advance filings, treating the false claims as fact. This is not a mistake. It is a pattern of refusing to withdraw false assertions once exposed. Such conduct is dishonest, prejudicial to the administration of justice, and inconsistent with the integrity required by a Missouri attorney. This is going to continue. I am submitting this rebuttal to the July 17, 2000 response from attorney Sarita McNeil via counsel Michael Downey concerning my ethical complaint. While Ms. McNeil attempts to characterize this as a mere litigation dispute for federal court, several of her actions constitute independent violations of the Missouri rules of professional conduct and are not isolated by litigation privileges or procedural form rules. These issues concern knowingly false statements, reckless disregard for the truth, and improper use of process servers, which directly implicates her duties of candor, honesty, and integration as a licensed attorney. Okay? 1, misrepresentation or an omission regarding process server notices. In her response to the OCDC, Ms. McNeil claims she submitted a request for process service in December 2024. However, on December 26, 2024, Ms. McNeil filed a notice of intent to use process server naming a company. She never submitted any return for this December 26, 2000 notice. No indication of whether service was executed or unexecuted. Despite no documented resolution for the December notice, a process server appeared at my home on February 12, 2025. Video footage is available. Ms. McNeil did not file her third notice of intent to serve me until February the 14th, at which time she again listed A1 Hugh Tech Civil Process Company per her documents and exhibits that she submitted to the OCDC. This contradicts her statement to the OCDC that the out-of-state company was requested, was made in December 2024 because of the address concern. So remember, she said that in December of 2025, which is 2024, she meant, she requested an out-of-state process server because she thought that she could serve me at the Citco at my place of employment in Texas. Then why was the guy in Michigan trying to serve me February the 14th. 12th. 2, false and reckless employment insertion, Citco. In multiple filings, Ms. McNeil asserted that I was employed as a shift manager for Citco Petroleum Corporation in Texas. This is unequivocally false, and she has been repeatedly advised of its falsity. I have stated through court filings that I have never worked at Citco in Texas and hasn't been affiliated with Citco in over 9 years. Okay? This right here about to get you. Okay? This the gotcha right here. When I did work in connection with Citco, it was as a contract worker through the owner of 3 Citco gas stations, not as a direct Citco Petroleum Corporation employee. Citco Corporation has no employment records for me, so I find it highly unlikely that they would accept service for me. Okay, Brownie, what you say? Let it cook. Let it cook. So again, line. I filed multiple motions to quash and strike her assertions, yet Ms. McNeil continues to file pleadings as if her claims were factual. Her own research from Checkmate and Rocky Reach shows that my alleged employee ended at all listed jobs, 4 different jobs, on October 10th, 2024, including Citco. And 3 of the other jobs, from her research, showed that I started on the same date, January 1st, 2015. Despite this, she claims I was served at Citco Corporation in Texas on February 17, 2025, almost 4 months after her own documents show my employment ended. This also was an attempt to service me by the deadline date given by the judge in January 21st, 2025 order, stating that service must be made to all remaining defendants by February the 17th, 2025. 3, abusive process via misuse of service attempts. Ms. McNeil's pattern of service attempts failing to resolve the December 2024 notice, dispatching a process server before filing the February 14, 2025 notice, and using an incorrect employer address constitutes abuse of process intended to create a misleading service record. 4, improper statement to the OCDC. By submitting an explanation that misstates the service notice timeline, Ms. McNeil provided the OCDC with information inconsistent with the official court document, document 53. And this is just the evidence table and service notice timeline with discrepancies, okay? And this is just the dates that they were filed, the notice file company, and then returned, how they were returned, and then service attempts here in contradiction or / issue. Okay. Missouri, this is a supplemental filing to them. I am submitting this supplemental filing to provide additional evidence of Attorney Sarita McNeil's misuse of court procedures and further examples of conduct inconsistent with the Missouri rules of professional conduct. Improper venue and forum shopping. Since you wanted to bring up PBE, let's talk about her. Let's talk about it, okay? Court records show that Ms. McNeil filed 2 requests for restraining orders in the Western District of Missouri against former defendant Vera Calvin. That's PBE. Oop, did I dox PBE? Sorry. In those filings, Ms. McNeil alleged that she resides and works in Boone County, which is located in the Western District of Missouri. Despite this, Ms. McNeil chose to file the current litigation, federal litigation, in the Eastern District of Missouri, where venue is improper. This directly contradicts her prior filings and suggests deliberate forum shopping and manipulation of venue rules to secure a more favorable forum. Such conduct undermines the integrity of the judicial proceedings and constitutes an abuse of process. Now, with her following her restraining orders and all of that stuff in the Western District of Missouri, and then them being denied and stuff like that, the outcome of them was not in her favor. So when she did this federal litigation for all of these defendants, and she was including PBE in them, she filed it in the Eastern District, where they wouldn't have a history of her filing restraining orders and stuff like that on PBE. But she's claiming all of this stuff in there, but she was already told she didn't have sufficient evidence and all of that stuff. But let's finish reading so we could, see the method to her madness. Hey, talking with Shayna. Denial of both restraining orders. Both restraining order requests filed by Ms. McNeil in the Western District of Missouri were denied. One was denied for insufficient evidence. In the second matter, Ms. McNeil herself requested a hearing, but then failed to appear, resulting in dismissal. These outcomes further demonstrate that her filings lack merit and appear designed to harass or intimidate rather than seek legitimate relief. Okay? So you couldn't come to court. You didn't even come to court. You requested a hearing because you didn't agree with them saying you didn't have sufficient evidence. So you requested a hearing so you can go to the hearing and bring up sufficient evidence. You didn't even show for the hearing. So it was dismissed. So that means you knew you didn't have enough evidence to even try to get a restraining order. So you took this case to the Eastern District so they wouldn't have the records of the attempted restraining orders and the information that you didn't even have. You didn't have any evidence of. So you could file a lawsuit and add PBE in that. Ethical concerns. The use of inconsistent venue claims coupled with meritless restraining order filings that were ultimately denied supports a pattern of misrepresentation, frivolous filings, and abusive process. This pattern is highly relevant to the OCDC's review because it shows that Ms. McNeil's misconduct extends beyond the federal litigation currently at issue and into her broader litigation history. And in conclusion, I respectfully request that the OCDC consider this additional evidence as part of its investigation into Ms. McNeil's ongoing misconduct, her repeated abuse of process, inconsistent representations to different courts, and failure to pursue filings in good faith demonstrate a disregard for her ethical duties as a Missouri licensed attorney. And then here is another supplemental filing. Opposition to application of mitigating circumstances to whom it may concern. I am submitting this statement as a standalone request that no mitigating circumstances be applied in evaluating attorney Sarita McNeil's conduct in this matter. In Ms. McNeil's prior disciplinary case, and I give the case here, mitigating factors, whether personal, medical, or otherwise, and they were they were personal. She said that her father was sick and all this stuff, which caused her to have these mental breaks and stuff like that, where she had I guess seek counsel, a therapist or whatever, and they had she was suffering from 3 undiagnosed mental disorders, previously undiagnosed mental disorders. So they were personal and mental, and whatever else she tried to use. Okay. were considered and contributed to a reduced sanction despite the seriousness of her misconduct. Those accommodations were intended to encourage rehabilitation and deter future ethical violations. The present complaint demonstrates that such leniency failed to achieve its intended purpose. Ms. McNeil has engaged in similar patterns of misrepresentation, abuse of process, and disregard for truthfulness in the current federal litigation. Her persistence in these actions show a willful disregard for the rules governing attorney conduct. Given her history and the reoccurrence of comparable misconduct, applying mitigating circumstances would not protect the public or uphold the integrity of the legal profession. Instead, it would send a message that the repeated violations carry little consequences. The focus of any disciplinary outcome should be on protecting the public, because at this point, well, we've been at a point, she's a danger to the public. She uses her law license as a weapon to harass and stalk and all of these things to people, to the public, deterring future misconduct, preserving confidence in the legal systems. For these reasons, I respectfully request that the OCDC impose sanctions without the application of mitigating factors. The end. What do y'all think about that? What do y'all think about this? And let me show y'all something else. Because this is another step. So and she's still adding stuff on the docket. Let's look at my other case. What's this one? Okay, so that y'all know that the end of last month, I struck Here for Hot Teas podcast that was being the account that was being circumvented, used to defame, bully, and harass content creators. I used that I struck a couple of their videos, about 4 of their videos on the channel that was using my content to defame my character and all of that stuff. And he rebutted them. He did a counter notification. And I said, now what? So here is his counter notification. Display name of the uploader. This is the video. I believe this video was wrongfully removed under the claim of copyright infringement. I did not use any visual footage from the claimant. I only used audio clips in a transformative manner for the purposes of commentary and news reporting, which is protected under fair use and give the fair use clause. The video adds new meaning, context, and commentary to the original. No, the fuck it don't. If the commentary said, for the original content for me, if it said apples, 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 the person that you was letting circumvent on your channel would say, see that, y'all? See how many times she said oranges? See that? That's not news reporting and adding new meaning. Changing the meaning, but not new meaning. To the original, which does not substitute the original material. I therefore have a good faith belief that this material was misidentified as infringing, and I request the restoration of this content. I contend to the jurisdiction of the federal district court in the district where my address is located, or if outside the U.S., the Judicial District of Northern California, and I will accept service of process from the claimant, declare under penalty of perjury that the information in this notification is inaccurate, is accurate, and that I am the owner and am authorized to act on behalf of the owner of the exclusive right that is allegedly infringed. I swear under penalty of perjury that I have good faith belief the material was removed due to a mistake of misidentification of the material to be removed or disabled. I consent to the jurisdiction of the federal district court for the district in which my address is located, or if my address is outside the U.S., the judicial district in which YouTube is located, and will accept service of process from the claimant. Justin Oyema. So he countered these. Okay. But when he countered these, he submitted a wrong address. A wrong address. He submitted the address that her for Hot Tea said they had moved. Remember when Maurice was trying to serve them? And she had moved? But he submitted the address that when Maurice got the subpoenas from his early discovery motions to the court, and from like PayPal and all that, and they gave him the proper address for them, they moved. So they wouldn't get served, I'm assuming. Evading service. So that's the address he put on here. So you know if somebody do a countersuit on you, hey, Just Jules, if somebody put a countersuit on you, a counter notification on your strikes, that means that you have to take them to court for copyright infringement. In order to keep the videos down, you have to submit to the court, to YouTube, that you have started the process to sue them for copyright infringement. So when he put the incorrect address on there, an address that not only Here for Hot Tea had verbally said on her channels before that they had moved. Y'all remember when she be doing the little cooking shows and stuff like that, and showing the little, her little daily routines and stuff like that, her little makeup tutorials. in the new apartments and stuff like that. Not to mention that they had returned mail in the Alabama case. So I say no. Not old Justin, tech guy, trying to get one over on Rente Talk. You didn't even give the commentary on the channel that you just told YouTube you did. You let a person with the terminated channel that's circumventing on your channel use the channel to defame me and use my content. And in agreement with your counter notification, you see how he had to agree that he was going to accept service when I sued his ass. So he can't accept no to service if I'm trying to sue him for copyright infringement. If he's providing a address that's not correct, inaccurate address. What should I do? So YouTube, I sent to YouTube that he had submitted an invalid address. And they said, well, if you have evidence of this invalid address, let us know, batch. Let us know. So I let him know. What's T? Okay. So I had to submit my information. Let me find it. Uno momentos. I ain't gonna put this one up because it showed their real name. Well, her real name too, and I ain't gonna put their real name on, even though they put my real name on their channel. I said this was August 12th. Dear YouTube, copyright team, I am submitting additional evidence in connection with my DMCA takedown and to formally dispute the counter notification filed by Justin Uyema. Here for Hot Tea Podcast. Justin knowingly submitted a false address in his counter notification. He is listed as a defendant in an Alabama defamation case where court records and return mail receipts confirm he no longer resides at the address he provided. His partner, Here for Hot Tea, publicly admitted on a YouTube channel last year that they have relocated, further proving the falsity of the address. The infringing video was also used to defame and harass me, as Justin has allowed a previously banned creator known as True T to circumvent their termination by using his channel to continue targeted harassment. I plan to file a lawsuit in the U.S. District Court for the Northern District of Georgia once my criminal investigation is resolved against True T, and I put the report number the police report number. I respectfully request that YouTube maintain the removal of their infringing video, treat Justin Uyima's counter notification as invalid due to his bad faith and fraudulent misrepresentation, and note litigation is in process for this matter, civilly and criminally. Okay. So that was submitted August 12th. Let me find. No, let me go to my sent box so I can show y'all the. Okay, I'm gonna share this screen with y'all. I moved it to where y'all can't see here for Hot T's name, but a piece of it shows Justin's name. And this is the return mail. You see this July 15, 2025, return to sender, not deliverable as address unable to forward. Meaning they don't live there no more. And they didn't leave a forwarding address. Okay. This was just July 15th. So this is very new. Very new. Okay. But I filed my strikes July 26th or 27th. Maybe a couple weeks after that return mail notification. So I sent that to YouTube and they sent me a notification. They asked me for the evidence. I sent that to them. I sent them the court case with their names on it. The service thing where they sent like the notice of service where they send out, say who they mail and whatever documents to. And with that, with their name and address on it. And the return thing with the address on there to return invalid address. No forwarding address. So they come sending me an email talking about some they had reinstated the content. I know you fucking lying. I said houseway. How? When I provided evidence of the bad faith submission of the counter notification with an invalid address, an inaccurate address. And they sent me back a response. What's today? The 15th. What day was this? I don't know where that mail at. And then they sent me an email back and said they apologize, but the content will be. Where's my phone? Because I took a screenshot of it. Time for this mess. Thank you for your notification. The content will not be restored. And then we have this. This video is no longer available due to copyright claim by Natavier Garnier. So, with that being said, we are making small strides toward getting justice on YouTube and with these frivolous ass lawsuits. Okay? And getting attorneys disbarred that does not deserve the right in the great state of St. Louis. Shout out to Tea Talk with your girl. In Missouri, a licensed attorney is continuing this shit. All of this unethical behavior. Hey, Terry T, baby. And again, we're fighting back. Okay, so that's all I have for y'all today. Is some other court stuff has hit the docket today, so I may talk about it tomorrow, but right now I need to catch up on a couple shows and things and whatnot, because you know, Kim, I'm not giving up. Like, I am not giving up. Because she has too many blatant violations, and y'all even see in the OCDC, they're trying to backtrack to act like it may just have been an incorrect, you know, a mistake from her research and all that type of shit. No motherfucking attorney that graduated from all of those schools or all of those accreditations will look at the research that she had, that she fucking submitted to the court, and think that that shit was accurate. And accurate enough to try to serve somebody at. So it's given very much intentional. Hey, Missy Love. Thank you, Marcella. Hey, First Last. Like, no. No. Like, it was one thing you put me in that shit and you couldn't serve me. So instead of you just letting it go, because you know in your fucking heart of hearts, you know in your heart of hearts that I had done none of this shit you accused me of. None of it. You chose to misrepresent the facts and tell that fucking court and submit paperwork to that fucking court and say that you fucking served me. I don't believe that company in Texas, I don't believe that process company, I don't believe they told her they served me, because she won't submit the documentation. She opposes submitting the documentation. If I say I bought this shirt from Fast and Nova, and you say no, you didn't, and somebody else say no, you got that shit from Shein, and I'm like, no, the fuck I didn't. I got it from Fashion Nova. Prove it. Here's my receipt. Boom, we're done. I'm not gonna oppose it. No. Oh, this is simple. This is simple. Here you go. They said it. So if I'm putting it in the court document, it's because they told me that this is what happened. They swore to me from penalty of perjury. I paid them to serve this girl at this place. They told me they did. They gave it here. Here's the documentation. Here's the documentation that where they said they did. Right here. Jefferson. Officer Garson. Here. Because when I called text 1A1 text Hoops, whoever the fuck they are, and spoke to Officer Garson, so you know I ain't lying. When I spoke to Officer Garson, Miss McNeil, oh yeah, it was some stuttering. Yeah, he didn't want to bust your ass out, but it was some stuttering. And I know he's not going to lie under penalty of perjury and say that they gave you the return that it was executed. Mm-hmm. I know that didn't happen. Because I know that just by him asking me, well, do you work there? Why are you asking me that? Your company allegedly gave paperwork to Sarita McNeil that you served me there. So I would have had to work there, right? I would have to be their employee in order for them to serve me there. But no. I said, no, I don't. Now he's stuttering. That's all I need, Officer Garson. You can have a great day. That's all I need. Hey, public enemy, criminal, whoever. Y'all remember John Witherspoon at House Party? Public enemy. Yeah, that's all I needed. He shouldn't have even been asking me if I worked there or not. Why are you asking me that? Because you served the summons at my place of employment. So you shouldn't have been asking me if I worked there. So, and I bet when the OCDC get a hold of this stuff right here, will they reach out to them? What will they tell them if they reach out to them? What will their private investigator tell them if they reach out to him? If you instructed him to take pictures of my license plate in my house. So, I'm going to leave y'all with that. Like I said, we straight up fighting back. We are fighting back. And from, I don't know, like from anybody else's outcome, but from what it looks like, I'm getting a little further in my investigation with the, I'm getting action with the OCDC. We're getting steps closer to getting this person away from the public. Because she definitely is a danger to the public. And she's weaponizing her law license against the public. And I hope and pray that it's not just about her losing her license. I hope they can find some criminal activity in this stuff. Because I believe she has done some criminal activity in this stuff. In all of these filings and all of this stuff, I believe this stuff is criminal as well. It definitely violates her ethical rules of misconduct for professional conduct. But I want to see if they can find some things that cross over into the criminal aspect. So, right, Just Jules. Even with this, like, I thought I was supposed to have been arrested a couple of times, like by night. And even if y'all look in anonymous Sarita McNeil's court filings, Most of the stuff that she's accusing people of is crimes. But she don't have any arrest records or nothing for reporting these crimes. Even with the stuff that she tried to report, I did a video on that too for the information by PBE, and she got all of that stuff in her membership as well on Pretty Brown Eyes PBE channel, where she's the stuff that she reported to the court. She didn't even mention me in the shit. And they closed them cases with nothing, no evidence, nothing. And again, even when she got doxxed or allegedly got doxxed, because I still think that she gave people her information, but she did say her name on the Silver's channel. So anybody say her name after that is not doxing her, because she said her name on there. And I think she did it purposely. And also, too, LB said her name. So I digress. But even with that, she said her father had gave Anthony none of the information. Her own father. Tomorrow I'll read y'all this fake ass I3 complaint. So y'all can see that her father seems to be just as damn loony as she is, but she did this shit out. I think her daddy is touched as well. That's just my opinion. I don't know if it's, you know, medically performed or not or whatever, undiagnosed or diagnosed, but in my opinion, I think she damn sure get it from him. Okay. But I digress. Thank you, everybody, for the super chats and the cash apps. We are back at it. Yesterday I was with the little grandbaby. She was here. We had a good little time, okay? So thank y'all for pulling up on the sis today. I'm feeling better, but I gotta go. Bye.